While addressing the issue, Justice Khanna has said that we are not saying there has to be a different law for politicians. Solicitor General Mehta further added that there is no question of your lordship's jurisdiction, just that doors are being opened for it would be impossible for prosecutors when any Kiryana owner or a labourer comes asking for the same exception. Mr. Mehta also went on to say that he has no ministry, no portfolio, no sign and no responsibility. Further, Advocate Singhvi interjected stating, I will not sign any files, but LG will also not refuse. ED lawyer Raju further added that the association of petitioner with the Vijay Nair was not part of the excise department or Delhi government. He was in charge of PDM. He was not getting any salary or income. Latest updates and back and forth coming in out of the Supreme Court. At this point in time, Advocate KV Dhananjay, senior lawyer of Supreme Court, also joins us on the program. Advocate Dhananjay, a lot of back and forth happening at this point in time. A lot of ground could be established and some precedents could also be considered. Some could also be snubbed. If Arvind Kejriwal does get interim bail, will it shock you and surprise you? I can't hear you. Sir, I can't hear you. Okay, I can't hear you, Advocate Dhananjay. Let me come back to you. In fact, let me take the same question to Chandni Preeti Shah as well. Chandni, would it be surprising if Arvind Kejriwal does get bail? You know, in your experience, rich experience as a lawyer, would this be the usual course of the law, or do you think any exceptions are being considered? Because like the Supreme Court, the Honorable Supreme Court also went on to say that this is an exceptional scenario. The Lok Sabha elections are going on and they only come once in 5 years.
This is absolutely an exception, especially because there's PMLA involved, right? Now, you do not get bail in PMLA. Generally, it is innocent until proven guilty. But
you mean guilty until proven innocent?
Yeah, it's otherwise over here.
But what about Sanjay Singh, Chandni, for the sake of argument? Sanjay Singh did get bail, so that means they had nothing against him, and a lot of people go on to surmise and have a conjecture that if you're getting bail under PMLA, it's as good as going scot-free.
Okay, so Sanjay Singh got bail only because ED did not oppose it. If ED would have had reservations about it, because the court asked ED that, do you have any reservations if we give bail to him? And they said it's okay. That means that either they got whatever they wanted to from him, or they cracked a deal that, okay, we have what we want. We know he's a pawn, okay, and we need to catch the bigger fish. So this is how it works. You do not get bail in PMLA until and unless the ED does not say that, okay, it is okay, you can grant him bail. Right now, in Arvind Kejriwal's case, the court has said that it is an exception, and they have said that if we can pass final orders, we can also give interim orders. Now that they have stated, whether they would give the bail or not, that's another thing. Now, secondly, this actually cannot be made a precedence for other cases. Number one, why he is only going to be given bail, if given, he will only be given bail because these are Lok Sabha elections and he is the chief minister. Now, for example, you said that tomorrow if someone else comes, if a hawker comes, or if a normal shopkeeper comes in the PMLA case.
Those are live shots coming in. Chandni, keep talking. Chandni, keep talking. But I just want to intercept and tell our viewers those are live shots coming in from inside of the Supreme Court. Arvind Kejriwal seems like he's wearing the same shirt he wore when he went to prison as well. Chandni, continue.
Yeah, so these theatrics, he'll continue doing this theatrics, for life. But as I was saying, if he is granted the bail, it is only because that there are Lok Sabha elections, and these conditions will be actually put. So in Sanjay Singh case also, there is a condition that his bail will not be made a precedence for the other cases. So same way, Arvind Kejriwal's bail plea, maybe there will be a condition that this bail plea is only because it's a temporary relief that we've given to a sitting CM so that he can, do his campaigning and all. But then it will be taken back, and the regular case will go on. This interim bail will not be,
Okay.
taken in consideration if you are applying for the regular bail. So these conditions will be put by the court if he is given the bail.
All right, Mr. Raju has also went on to say in the Supreme Court that despite having nothing to do with the excise department or the Delhi government, Rajalakshmi Joshi, Vijay Nair was allowed to occupy Cabinet Minister Kailash Gehlot's bungalow adjacent to the Chief Minister's house. Now, this also, may be a fact that could or could not affect what happens today, but obviously, this does tell you how important Vijay Nair was in the Aam Aadmi Party.
Yes, definitely. Mr. Arvind Kejriwal has flouted every rule, everything possible. So, all these theatrics that you were talking about right now, just imagine that the man wears, a simple shirt. He dresses up like a chaprasi, but he spends a horrendous amount on his sheesh mahal, on the renovation of his house, of his bungalow. So that, he pretends to be an Aam Aadmi, but his lifestyle is nowhere close to being an Aam Aadmi. So, he has actually flouted everything possible. So, from Mr. Vijay Nair, whom, he has called as the Mera Ladka hai, and, he has introduced them on Zoom calls, etc. So, all of that, there is a lot of evidence. And just imagine that he has destroyed close to 170 iPhones. That kind of an evidence is there. So, there is definitely no doubt that there is a lot than what meets the eye. So then, there are also these accusations of him getting funding from Khalistani elements also. So, there is a huge amount of, there are a lot of accusations against him, which definitely need to be investigated. And after the ED, the CBI wants to investigate him, then the NIA wants to investigate him. So, this is not going to end so easily. So, like I was telling you earlier, that even if he is given this interim bail,
but they allege that it's all part of a grand political vendetta program.
How can Mr. Vijay Nair be operating from his own minister's house if what was the role of BJP to play in that? And just imagine that the Congress was the one who has actually made a huge hue and cry about this. So the BJP has nothing to do with this, actually. Very frankly, I would say that the BJP is getting credit for this arrest, whereas it was actually the Congress that actually took it up very, they were very vehemently against this, and that was for a different reason. They were trying to pin down Mr. KCR in Telangana, and what happened is because of their association with Mr. Arvind Kejriwal and the Aam Aadmi Party, both of them got tagged together, and today both the parties are in a huge problem there. And neither is Mr. KCR's daughter getting bail, nor are any of those Aam Aadmi Party leaders getting bail. So, the Aam Aadmi Party cannot go and say that every central agency possible and the judiciary also is under the guidance of the BJP. So, and that also the Congress has made a huge claim.
Okay, let's get. All right, let's also get Advocate KV Dhananjay into this conversation as well. Advocate Dhananjay, I hope you can hear me and I can hear you now.
Yes, sir. I can hear you very well.
All right, your observation of what's happening in the Supreme Court. A lot has been said and done in the Supreme Court in the last few hours, in the last few minutes. The same has been done on our show as well. Where do you stand when it comes to Arvind Kejriwal's bail, whether it's interim or not? The court says that these are exceptional and overwhelming times, and a person like Arvind Kejriwal must find exception because of the circumstances that prevail. Does it in any way set a wrong precedent in any category? Because you can have exceptional circumstances come about for a number of people who have done wrong things or are up against the law.
Well, the court could grant him bail, but the problem is the reason that the court will assign for granting bail. It would really be a very wrong precedent for the court to say that because this man has an election to canvass, the court would consider granting him bail. I think that would really be a very improper reason, with due respects to the Honorable Supreme Court, to consider a grant of bail. I think it's perfectly fine for the court to say that they have considered the objection given by the ED for why he should not be granted bail. That is to say, Mr. Kejriwal would argue that he is, of course, innocent, and that there was no good justification for the ED to have arrested him, so on and so forth. So it's important for the Supreme Court to confine itself to those other reasons. But if the court were to step and say that because this man has an election to canvass and that they would consider granting bail for that reason, the court would also be undoing a good amount of jurisprudence that it has itself evolved over the last 20 years. In 2002, it is the Supreme Court that said that people who vote should have greater disclosure, and that is how the court said that every candidate should in fact be disclosing far more information than what was mandated by the law until then. And it is the court that set up special courts to try MPs and MLAs that have been accused of crimes, so that the trials would in fact happen faster. It is a court that said when a person who is a sitting legislator, whether be a MP or a MLA, gets convicted, then he will be automatically disqualified. That was not the position until then. So for a court that has evolved a jurisprudence of this nature to now say that, wait, someone has an election to canvass, so we will in fact let him out on bail, I think is going to undo that much of jurisprudence, because the most that you would do by successfully canvassing is to put someone as a member of parliament or a state assembly. But whoever is a member of parliament or a state assembly is already subject to stringent disqualification measures. Why? Because of what the Supreme Court has said. If a person is a sitting MLA or a MP and he in fact is convicted, he's automatically disqualified. If a person is a sitting MP or a MLA and then he is accused of a certain crime, then he is his trial is speed-tracked. So I think the court should not be assigning this as a reason to grant him bail, and it would be great if the court would find some other better reason to grant him bail. Because something like he has an election to canvass, well, even if the court would say that whatever order it passes should not be treated as a precedent, you would not expect a court to pass an order and say it should not be treated as a precedent and do that every month. Just now, the other panelists were talking about other instances where the court granted bail and said whatever reasons it gave should not be treated as a precedent. You would want, that should be so rare, like, once in 5 years or 7 years, a court says, I'm going to pass an order and I don't want this order to be treated as a precedent.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.